Welcome, and thank you all for joining today's virtual panel discussion on reproductive justice, a guide for prosecutors. My name is Rachel Marshall, and I'm the Executive Director of the Institute for Innovation in Prosecution at John Jay College. The IIP provides a national platform to bring together prosecutors, policy experts, and the communities they serve to promote data-driven strategies, cutting-edge scholarship, and innovative thinking. The IIP champions criminal justice reform policies that advance community-centered standards of safety, fairness, and dignity. We host regular webinars, so please subscribe to our mailing list if you have not already to ensure that you're up to date with our news and don't miss our events. And I believe we will be putting that link in the chat. Last week marked the one-year anniversary of the Dobbs decision, reversing well-established protections for reproductive healthcare access. Since then, many states have enacted or are working to enact restrictions on access to abortion. As a result, suddenly prosecutors around the country are being asked to perform a role they never asked for and likely never contemplated, to be wedged in the middle of the deeply personal decisions made by patients and their doctors. This new role is at odds with the responsibility of prosecutors to promote safety and justice. For today's webinar, we'll examine the fundamentals of reproductive justice, its place in the legal system, and what our panelists foresee reproductive justice will look like in the future. Our discussions include a wide range of subjects, including the science of reproductive health care, the state of the law, and the potential effects of interstate travel limitations on access to reproductive health care. Our discussion seeks to empower prosecutors with the knowledge, expertise, and tools to understand this complex and emerging area of law, and give you as prosecutors the guidance to make the right decisions to promote not just reproductive justice, but economic and racial justice as well. Despite how politicized the topic of abortion access has become, this is a conversation that is fundamentally about healthcare. And we know that no community can be safe without access to good, timely, and compassionate healthcare. So I thank you all for joining us for this critical conversation today. It is now my honor to introduce our three esteemed panelists for today's discussion. And in the interest of time, I'm going to introduce them very briefly, and we'll be placing a link to each of the panelists' full bios in the chat. And we encourage you to read about all of their experiences and accomplishments through the website we are dropping. First, I'm going to introduce Shannon Taylor, who in 2011 was the first woman elected as Henrico County Commonwealth's attorney after years of service as a professional prosecutor at the local, state, and federal levels. Since taking office, Commonwealth's Attorney Taylor has focused on issues related to mental health and victims' rights, while also advocating for broader reforms within the criminal justice system. Commonwealth's Attorney Taylor currently serves as president of the Virginia Commonwealth Attorneys Association. Next, it is my honor to introduce co-dean and professor Kimberly Mutcherson of Rutgers Law School. Dean Mutcherson is a reproductive justice scholar whose work sits at the intersection of bioethics, health law, and family. She has a particular focus on assisted reproduction, abortion, disability, and medical decision-making for pregnant women and children. And finally, it is my honor to introduce Dr. Brandi. Dr. Kristyn Brandi is an OBGYN, family planning specialist, and steadfast advocate of reproductive autonomy for people of color. Dr. Brandi works to dismantle oppressive structures in reproductive health to help every person achieve their own reproductive justice. Dr. Brandi currently serves as the Darney Landy Fellow at the American College of Obstetricians and Gynecologists. Welcome to all our panelists. We are honored to have you here with us for this discussion. And I'm going to dive right in with some questions, but I did want to let everyone watching know that we will reserve some time for Q&A at the end of this discussion. And please put your questions in the chat throughout this conversation. We will try to get through as many as we can at the end of today's program. So I want to start by establishing some terms. I'm going to turn to you, Dean. What does the term reproductive justice even mean? And how is it different than the term reproductive rights, for example?
Great. Thank you so much, first of all, for having us here, for having me here, and for having us all here to have this conversation, which is just such a critical conversation to have. So my bio, you introduced me as a reproductive justice scholar. And so that is a term that is very near and dear to my heart. So I'm glad that we are starting there. in part because a lot of folks use the term reproductive justice as though it is the same as saying reproductive rights. And I think it's really important to make the distinction here. So reproductive justice is a movement that was started by Black women in the mid-90s. These were women who were doing all sorts of incredibly important activism in their communities and who got really frustrated because the mainstream reproductive rights movement, which then and frankly now was largely being led by white women, and not just white women, but white women with class privilege, and the issues that those mainstream organizations were focusing on, particularly once they got sort of, I was going to say bogged down, but that feels like an unfair way to describe it, because they were focused on abortion because there were so many laws that were being passed. But that they were spending so much time on abortion and questions of choice without thinking much more broadly about the many, many issues that have affected particularly communities of color and especially Black communities. And so reproductive justice was founded as a counter narrative, basically, to reproductive rights, which had become so narrow. Reproductive justice focuses on three basic tenets. They focus on the idea that women should be able to decide if they want to have babies. Two, they should be able to decide if they don't want to be pregnant and have access to the tools of terminating pregnancies or avoiding pregnancy altogether. And finally, and the last one is the one that really I think is so important for people to remember, which is that women have the right to raise the children that they do have in safe and healthy environments. And so what that means, obviously, is certainly abortion, contraception, choices about childbirth are all a part of reproductive justice, but so is environmental justice, so is criminal justice reform, so is access to education, access to high quality and affordable childcare. You know, it really, really runs the whole gamut. And so reproductive justice is really a way of thinking about the fact that people are not just focused on pregnancy and childbirth, but the entire spectrum of what happens after you actually have a child. And so it is intersectional, it is human rights based, it focuses on communities that are at the margins and not communities that are at the center. And it thinks really deeply about the ways in which reproductive laws and reproductive oppression function really differently in the lives of communities of color than is true for majority communities. So I'll leave it there as an opening, but happy obviously to talk about it more as we move forward.
Thank you for that, Dean Mutcherson. And I'm going to turn to you, Commonwealth's Attorney Taylor. With that understanding of those terms in mind, why, in your opinion, should prosecutors care about reproductive justice?
So yes, first of all, thank you for letting me be a part of this great panel. And I love how Professor Mutcherson talked about, the distinction between, justice and rights. And I think to highlight these categories that she was talking about, whether it is, medical care, housing, access to anything, that the reality is that we know that there is a disparity in the access to healthcare when it comes to women of color. And the fact that I've heard different podcasts is devoting a week of conversation of what's happening out there, and women of color not either being being heard when trying to relate issues regarding their pregnancy to their caretaker, or not being believed to the extent the severity of what they're dealing with. I mean, my gosh, it takes Serena Williams to come and talk about her issues that she was dealing with that finally made people kind of listen to what was happening there. But it really, like we say with a lot of things, it should not take some high profile personality to bring something to the forefront that we should and have been knowing about for all this time, but not taking care of it. And the reality is that when women are not being given the appropriate access to healthcare, the worst situation can occur, which is people are dying. And if people die because they are unable to get the appropriate healthcare and access to that appropriate healthcare, then that is a public safety issue. And I think as my colleagues here on this call know, as being prosecutors, public safety is our lane, and therefore we should care.
Thank you so much for that. And we're going to now turn, and Dr. Brandi, I'm going to turn to you and stick with you for a little bit to talk about some of the science that I think, as I mentioned in my opening remarks, now prosecutors are suddenly being thrust into this world. So let's start with some of the basics. And it may sound like an obvious question, but I'd like you to define what is pregnancy and how is it misunderstood in mainstream coverage of this topic?
Well, thanks for the question, and echoing thanks for having me on this amazing panel of people. It's really a basic question, and yet it's not, because I think there's so many opinions and feelings about pregnancy that it is important to kind of start there and clarify. So pregnancy is the implantation of a fertilized egg, which is an egg that has a sperm that has entered it and is now attached to the wall of the uterus. And I say all of those terms, knowing that, it may be a little confusing, but it's important to recognize, one, that pregnancy is not necessarily at the time of conception, which is something that we're talking about a lot when we talk about these laws. We hear a lot of stuff about conception. But conception isn't something actually that can be determined medically. We have no idea, other than if you're going through an in vitro fertilization process where we ourselves in the medical field put the sperm and the egg together. We really have no clue when conception happens. So that's why we consider someone pregnant when they have that fertilized egg attached to the side of the wall of the uterus, called implantation. The other issue around conception is that it really confuses the idea of how pregnancy develops, how long a pregnancy is developing for. So often when I'm talking about someone being pregnant and measuring how far along they are, it's often called the gestational age or gestational duration. And usually that's based on someone's last menstrual period. The reason for that is that's kind of the closest thing that we have to when a conception would happen and an implantation would happen. The problem with that is that it's 2 weeks before someone actually becomes pregnant. So that is also kind of confusing for folks, and particularly for people writing laws around abortion and creating bans around certain gestational age limits. We often have to look through the law and kind of figure out, well, is this written based on how medical people date pregnancies, which is by their last menstrual period, or is it based by conception, which hypothetically is somewhere 2 weeks after someone's last menstrual period, maybe. So I think that helps to illustrate some of the confusion, that there is a differentiation between the science when someone is considered clinically pregnant versus this conversation around conception and when life begins. That when life begins part is really a values issue. It's not really a scientific issue. And so it's not something that really I can comment on about when life begins. But I can say at this point in a pregnancy, this is what's developed, this is what is developing or what will develop soon. That is science. That's often not based in values. But some of that gets mixed when I'm taking care of patients. For example, we talk about quote unquote heartbeats in these heartbeat bills. Often what is being described is what we see on ultrasound is cardiac activity of the cells that are going to eventually become a heart, but they actually don't indicate a heartbeat. That being said, when I'm looking at this ultrasound with my patient and my patient points to that finding is like, oh, that's the heartbeat. And often I'll say yes, because that's the way that they internalize that information. That's the way that medicine is socialized. But I think when we're talking about medical care, it's really important to kind of know the definitions and figure out how that plays into clinical care. But unfortunately, the law doesn't have that kind of wiggle room to have all these interpretations be allowed.
Right. And so on that note, in terms of continuing to understand the definitions, we've been talking about the definition of pregnancy. Let's talk about the definition of abortion. And when you talk about that, if you could also talk about the difference between a self-managed abortion and an abortion procedure.
Sure. And again, another unfortunate area of confusion. So in the medical field, whenever we say the word abortion, that means the ending of a pregnancy before 20 weeks of pregnancy. This includes an induced abortion, meaning someone does something, takes medicine, has a procedure to end a pregnancy. Or a spontaneous abortion is the medical term for a miscarriage, when the body recognizes something and expels the pregnancy. And so abortion is ending a pregnancy, but colloquially, often we're talking about the induced abortion when someone does something to end a pregnancy. There's two options for ending a pregnancy within the medical space. Often it's medication, where you take medications to induce bleeding and cramping that looks very similar to a miscarriage process. And there's procedures, which I do also want to clarify the term, because often you'll hear the term surgical abortion, which is often not accurate. When I think of surgery, I'm a surgeon, so I think of C-sections, I think of major abdominal surgery where I'm cutting someone open, which is not what abortion looks like at all. Abortion procedures are 5-minute office procedures that are done often with either local or some like light sedation that take about 5 minutes to do using non-sharp instruments. So that's the medical versus the procedural. And then you mentioned self-managed abortion. So self-managed abortion is someone that is obtaining abortion care outside of the medical field, meaning that they didn't go to a doctor's office or a healthcare provider's office to get pills or to have a procedure. This could look like people self-sourcing medication, going online in a non-medical space and getting pills, going across the border to get pills in other countries that are often over the counter. And this could also use things like herbal medications or other types of ways to end a pregnancy outside of the medical space. And I just want to name up front that self-managed abortion is safe, it is effective, especially if people are using the same medications that we use in clinical practice.
And just to follow up on that, is that also true for procedural abortions? There's a lot of characterizations sometimes in the media around abortions being so dangerous. Can you speak to that?
Yeah, and that's a question I get very commonly in clinical practice. So one of the first things my patients ask me is like, is this going to be safe? And I'm always shocked by that, but I shouldn't be. I think that's because of the legacy of when abortion was illegal and people were getting these quote unquote back alley abortions, that often it was done with unsafe equipment that wasn't sterilized. There was no real medication option at that time. And so back then it was unsafe. But now, because it's legal, we've been able to do more studies and test things. We have medication abortion, and all of that is what I like to call ridiculously safe. It's one of the safest medical procedures that are out there. The medications that we use for medication abortion are quoted to be safer than things that you can get over the counter, like Tylenol and ibuprofen, penicillin. And the procedures themselves are incredibly safe. And I think the way I think about that, there's like data that suggests that it's safer than certain things, including other procedures like oral surgery, eye surgery, like cataracts, safer than driving in New York City, apparently, according to one study. But the important context is that it is much safer than continuing a pregnancy. That I quote patients that a procedure or medication for abortion is about 10 times safer than natural childbirth and about 20 to 25% or times safer than a C-section. And so that gives you context. It's actually incredibly safe to have an abortion. But because of this history of care when it was illegal, people think that it's unsafe. And that is a concern as more and more states ban abortion care. What is the safety going to look like? Even though it's new medicines, new procedures now, there is still some concern about the safety afterward.
I want to turn now to abortion restrictions and turn to you, Dean Mutcherson. As we know, and as many of us have been reading about, there are many abortion restrictions that have begun to take effect post-Dobbs and others that are continuing to be proposed and passed on what seems like the daily. Can you outline for us what you're seeing in these bills or laws and how they're seeking to criminalize abortion access and whether you see other changes in this area coming down the pipeline?
Yeah. So, I mean, one thing that I think is really important for folks to remember is that abortion in this country has been severely restricted for a very long time, right? There haven't been bans necessarily in place only because the Supreme Court said you couldn't ban unless it was in the third trimester and then after viability. So there were already lots of ways in which it was hard to access abortion in this country. And then what we saw, obviously, right after Dobbs, a few states had trigger laws already that were just ready to go as soon as the Supreme Court said that Roe fell. But even with those, there ended up being some litigation and questions about when they could go into effect. But mostly what we have seen are states, and we have about somewhere between 14 to 16 states. And I wish it were easier to give an actual number, but it's not because there's so much litigation that from day to day, things are getting enjoined and then they're not enjoined and all of that good stuff. But what we see in most states are gestational bans of various, lengths. So, 6 weeks gestation, 15 weeks, 20 weeks. And there's no rhyme or reason to any of that, right? They're just basically numbers that are being pulled out of the air at this point. And then once a ban is in place, most of those bans are going to target the people who are providing abortion services. So people like Dr. Brandi, and there are potential fines, there's potential to lose your license to practice medicine, potential obviously to go to prison, which is obviously a very significant repercussion. Most of these bans have various exceptions. It used to be under Supreme Court jurisprudence that you could not have a constitutional abortion ban unless it included an exception for the life and health of the pregnant person. To the extent that there are exceptions now, they tend to only focus on life and not on health. So for instance, if a physician said, well, we need to perform the abortion now because that will preserve this person's fertility, that is not going to be a life exception. And even the exceptions that do exist, and we know this from seeing all these awful, awful stories that are coming out about miscarriage mismanagement, even where medical exceptions do exist, it's not entirely clear when they kick in. And how broadly they are going to be interpreted. And that really, frankly, goes back to this audience, right? Who is willing to actually say this exception is super narrow and you move too fast or you shouldn't have performed an abortion in this set of circumstances. Most of these statutes do not have exceptions for rape or incest, which was much more common before, but a lot of these statutes don't have those exceptions anymore. We're going to talk about this a little bit later, but another category that we're seeing are obviously issues about interstate travel. The easiest way to attack this is what Idaho did, which said that you can't transport a minor over state lines, nor can you provide a telehealth abortion even to a minor without, running afoul of the law. But there are lots of state legislators who are talking about, how do we punish people for leaving the state, getting a legal abortion elsewhere, and then coming back? And the interstate travel issues involved with that are obviously deeply constitutional. And so we'll see how that plays itself out. Justice Kavanaugh, in his concurrence in Dobbs, said, oh, this is not going to be a big issue. It's so clear that you couldn't possibly decide that that's illegal. And yet we see states who are trying to move into that direction. So that's a lot of what we're seeing. And that is, these things are sort of on top of what were already existing rules, things about, what you have to say, what kind of consent you have to get, things about waiting periods, rules about who can perform an abortion in a particular state. So lots of rules that were already in place, and now layered on top of that are these laws that are saying you can't perform abortions at all. And again, before Roe fell, you could not ban abortion before viability. That was simply unconstitutional. But the bans that we are seeing now are consistently bans that are before fetal viability.
Thank you for that.
Which I should say, in and of itself, is not a stark line. So even that line was not necessarily that useful, but at least it was a line.
Yeah, I want to turn to you, Commonwealth's Attorney Taylor, and get your reaction as a lead prosecutor in Virginia. What has been your reaction to not only the decision of Dobbs, but the subsequent changes that we're seeing and that we just heard about happening across the country? And you touched on this a little bit in your opening remarks, but what does this raise for you as a prosecutor in terms of public safety concerns?
Yeah. So first, I really should clarify, that I'm definitely here in my capacity, just as the prosecutor for Henrico County, and not speaking as the president for the association. And I like to also, show my age, which is we had a full page in our newspaper dedicated to the, abortion laws by state. And so I want to first follow up on what Professor Mutcherson has just said, which is the fact that we have so many different interpretations. The idea that we had, like as she indicated before, the 14 states that did an all, out ban, and the idea of what is the difference between allowing a woman access to healthcare because her life is in danger or her health is going to be, impacted. Right there, you have a varying degree of what that means in terms of interpretation. And to kind of quote from one of my colleagues who talked about this, the fact that we have this and the fact that we had Justice Kavanaugh make the comment and the opinion that Rachel, you just mentioned, just shows that they were evil geniuses and knew exactly what they were doing and creating chaos in this nation, or they literally had no idea that saying that this is a states' right issue, that they would create the chaos that they have created. And I love what Dr. Brandi said, because, when the law for us, for the practitioners, words matter. The idea that you're trying to put some type of numerical aspect to the gestational development of this entity, how are you going to prove that? Unless I'm like literally in the room and seeing this, seeing something happening there. But even then, I can't promise that to Dr. Brandi that egg has been fertilized that very moment in time. Like, when we have to prove, cases beyond a reasonable doubt, how are we going to do that? How do we take these, the laws, like the heartbeat bill? Clearly, as we know, I'm sure, again, all of my colleagues in the 50 states that may be represented on this call get so frustrated with our legislators because they literally put into law, concepts that they all want to get behind and are great sound bites. But when it comes to the actual, the machination of the laws, they're a complete disaster. And so, I know that for myself, generally speaking, it blows my mind that we have this complete chaos on something that touches something that is near and dear to me as a woman, which is my healthcare. And the idea that there has been, which could be argued, a very reckless response. And I mean reckless just because we are throwing out terms that no one has any idea what they really mean when it comes to the idea of proving a case in the criminal courts.
And
can I just add one thing in there? I want to go back to the evil geniuses point, because I think that our Supreme Court justices are very, very smart people, right? So they had to understand what the patchwork was that they were creating in doing this. And then on the part of state legislators, I do think that there were some folks who didn't realize just how far their bills were going, and I say that because some of them have said so. Right. I didn't realize that this is what the outcome was going to be. But part of the power of so many of these statutes is that nobody knows what they mean. Nobody knows how far they go. And hospital lawyers are conservative sort of by nature, right? Their job is to keep their hospital from being sued and from being in the news and all these other good things. And so they err on the side of tremendous caution. And so even if they read an exception and think maybe this falls into it, or the doctor is saying, I'm confident this falls into the exception, they might lean towards, well, let's let her get a little sicker. Right. Let's let her sit in the parking lot for a couple of hours and then have her come back in. And that's pretty horrifying. It's horrifying for the patient. It's horrifying for the healthcare provider. And it's horrifying for our healthcare system, frankly.
Right. I think that's right. And Commonwealth Attorney Taylor, you mentioned some of the challenges in proving in court, given what we heard from Dr. Brandi about the difficulties and the blurry lines around a lot of these issues, the difficulties for determining beyond a reasonable doubt whether someone broke the law in obtaining an abortion, given that there aren't these defined lines that so often it's falsely portrayed as. I want to take a step back for a second, if we could, and think about who are all of these laws? Who is this conversation even really most impacting in terms of demographics? I was going to ask you, Dr. Brandi, if you could talk about who are abortion restriction laws impacting the most, and who do the data show are really seeking abortion access? And as a result, which communities are having the most difficulty accessing healthcare in light of some of the newer restrictions that we've been seeing and talking about?
Sure, and I do really like that. That we are talking about this and centering who are the people that are most impacted by these laws. Because often I assume it's not the people that are in this room right now. There are people on the ground that are, in dire need of care and can't access it. I will say generally abortion care is sought by people that often are already marginalized. And so we see that abortion happens more often in people that are low income, people that identify as people of color. And so if you think about, well, what does it take for those people that are marginalized, that have difficulty accessing the healthcare system in general, now tell them that they have to access that healthcare system 2 states over. So the logistics of being able to navigate care are even harder. And so it even further perpetuates those inequities in healthcare. And so we've seen some data preliminary coming out of Texas because of the SB8 kind of led the charge of all these spans. And so we saw that particularly people of color, people of low income, were just not able to access care after SB8. And we're going to be seeing more and more data coming out. We're seeing more generalities right now about people in certain states not being able to access care. We haven't gotten the granular numbers just yet about people in certain demographic groups that haven't been able to access care. But generally, we suspect that people that won't get care, BIPOC folks, people low income, people that are LGBTQ, a lot of that has to do with, do they have the funds to travel? Do they have the means for childcare, other support systems that are needed to be able to take a plane ticket or to drive 2 states over? Also, there's concerns about people that physically cannot travel, people that are undocumented and may have to go through checkpoints in their state. And so that may be too worrisome for them to go through the process to travel to get care. People that are incarcerated, that physically cannot leave there, that you don't get to pick what place you're imprisoned. And so while some states have access for people that are incarcerated, others in these restricted states likely don't. People that have disabilities also, there are concerns about transportation and whether or not people will be able to access care. And I want to also name specifically teens that have all of these barriers around, can they afford it? Can they travel, taking time off of school, perhaps, but also they have additional barriers that people may not consider, like parental consent laws in certain places that had existed before Dobbs, but also create these additional barriers to people being able to access care if they're a teenager. So again, often marginalized communities, people that already didn't have access to the healthcare system. And we expect that this is going to perpetuate in other types of health inequities. Will these people also be able to get pregnancy care if they're now continuing their pregnancies? And so I think we'll talk maybe a little bit more about that later, but the impact of this is not just within abortion, but it's also going to be impacting the healthcare system as a whole as we move forward.
Thanks. I want to move on or back a little bit to something that you touched upon earlier, Dr. Brandi. When we were talking about definitions of abortion, we talked about medication abortion briefly. And I wanted to turn to you, Dean Mutcherson, because one of the challenges we've seen a lot around abortion access post-Dobbs has come in the form of restrictions, specifically on medication abortion and somewhat unusual restrictions. And I was hoping you could kind of give us a lay of the land and the current status of access to medication abortion and challenges to that access.
Yeah, that's been quite the roller coaster. So, one of the things that is really important is that medication abortion is a huge proportion of abortions in this country, right? 90+% of abortions in this country are first trimester, and more than half of those are medication abortions. So if you want to stop abortion, you have to go after medication abortion. And part of what's tricky about that is that one, you don't necessarily have to go to a doctor to get the pills, right? There are ways that you can get them on the internet. There are people who will send them to you. And so we know that there are people out there who are accessing medication abortion, whether it is allowed in their jurisdiction or not allowed in their jurisdiction. And because of that, obviously what we're seeing are state legislators trying to figure out, how do we decide that these pills can't be sold in our state, which is really significant overreach, right? I mean, one of the things, if you're sort of a law nerd, that's interesting about all of this are the incredible ways in which states are legislating in areas where they have no business legislating, right? Whatever you think about abortion, states don't get to decide certain medications that are approved by the FDA can't be sold within our borders, particularly when there are medications like the medications that are used for medication abortion that are also used for other things. So trying to make people not have access to pills. Obviously, if you provide pills to somebody in a state where abortion is banned, you are violating the abortion ban in that jurisdiction. So you put yourself at risk in that sense. If a woman shows up at an emergency room and there is speculation that she may have tried to perform an abortion using medications, she is at risk at that point for having violated whatever ban on medication exists in a particular jurisdiction. And of course, we have the real lawsuit, which is the one that is seeking to literally take the approval of mifepristone away, which again, right, these are things that are just sort of off the charts in terms of what folks are trying to do here. The good news, depending upon your perspective, the good news is that the mifepristone lawsuit ultimately, after the incredibly cynical way in which it came to be, did get its brief viewing in front of the U.S. Supreme Court, and essentially where we are sitting now is just in stasis. So mifepristone remains approved. It remains approved with all of the changes that have been made in the 20 plus years since it was initially approved, and so it can be dispensed, it can be used, and that will be the case until we're done with this litigation that started in Texas and is now going to wind its way ultimately back up to the Supreme Court again. That's sort of inevitable. The other piece of the mifepristone issue, of the medication abortion issue, is telehealth. And so one of the things that we saw during the pandemic was these exceptions that were made for all types of care that moved to telehealth, and there were restrictions that were peeled back for abortion access during the pandemic, allowing people to have more access and broader access to telehealth, which, as Dr. Brandi told us, these are very safe procedures, right? So it's not that you have to show up at a doctor's office 2 or 3 times in order to terminate a pregnancy. But now we're seeing efforts to roll back that as well. So states saying you can't provide telehealth across state lines, even for medication abortion. So there's really, what I said in the beginning is, I just want to reiterate it. There is no way to stop abortion in your jurisdiction unless you stop medication abortion. And it's very, very hard to stop medication abortion. And well, we'll talk about criminalization later, but I have some concerns about where that ends, that process.
Sure. And with that in mind, I mean, Dr. Brandi, I wanted to ask you, what is the significance of these attempts at restricting telehealth and restricting medication abortion access? What restriction does it, what are the implications for your patients and for patients who are pregnant across the country?
Yeah, and I think, as Dean Mutcherson alluded to, taking down medication abortion is really shutting down a lot of abortion care that's happening across the whole country. So medication abortion is about half of all abortions, and it really has been increasing over the past couple of years. It used to be not as popular, but with telehealth, with more providers being comfortable with providing these medications, it has really been a huge tool to improve access to care. We talked about people that may not be able to travel to get to a clinic or go to the next state over, but medication abortion has become more and more accessible because of telehealth, being able to mail it to your house. It has been a huge tool to be able to expand care. And that's great. And especially because it's something that is 95 to 99% effective. And this is with the combination of mifepristone and misoprostol, 2 medications together. There are regimens that allow for just the second medication, misoprostol only. That is also pretty safe and effective. And so I worry about, we're going to be rolling back all of those things if people are targeting medication abortion, telemedicine, as a way to decrease access. And I think it's also important to name, you alluded to it a little bit, Dean Mutcherson, but there's lots of other uses for these medications too. So we've been talking about abortion a lot. These procedures, the medication regimens, are also the standard of care for miscarriage management. And so if the mifepristone lawsuit ends up taking away mifepristone, we also lose the gold standard for that, for miscarriage management too. And there's a lot of other uses for these medications. Mifepristone was initially invented for an endocrine disorder, nothing even close to related to gynecologic care. But if it goes away, what does that mean for the people that are accessing this medication for non-pregnancy reasons? And it's actually been shown potentially to be helpful for things like fibroids and endometriosis management, other like women's health issues that really need, newer treatments and newer innovations. We will be going backwards by losing access to this medication. So all of those patients will be impacted by not having this medicine. But I also just want to name that it's not just the patients that are impacted. That is going to be devastating, but also this precedent that's being set through some of these lawsuits, particularly the mifepristone lawsuit, about who can decide if medications are approved or not? That is a really scary thing, not just for abortion, but all kinds of healthcare. And what is the next medication that's going to be challenged? So a lot of concerns, particularly on this mifepristone case and how it lands.
I want to move on to a topic we sort of briefly started to allude to, and around interstate travel issues. And Commonwealth's Attorney Taylor, I'm going to start with you because we have an audience with us today of many prosecutors across the country, including chief prosecutors like you, as well as line prosecutors who are in court every day. And some of the prosecutors with us today are in states where abortion is restricted, and some are in states where abortion is more readily available. I'm going to not say not restricted, given some of the things we just talked about. But why is this an important topic for all prosecutors, regardless of the state of the law in their jurisdiction post-Dobbs? And how does it affect every state, regardless of whether there have been new abortion restrictions put into place post-Dobbs?
So, I think there's two approaches to this. First of all, it is whether or not you are the prosecutor who is approving a warrant for somebody, and this is to suggest that the individual has somehow violated, your home state's law, but that that they have gone to Virginia in violation of your home state's law. So first, you have to be the one to say that, yes, I think that the law that we have for my state is in fact constitutional, due process is there, and you go ahead and you say that. And then for the location and what we call the asylum state, the place where someone has gone to, it's important to know about the players on your state level. So while many of us are elected on the local level, it also matters who your governor and who your attorney general is, because for the extradition process for Virginia is that the extradition request is received by the Office of the Secretary of the Commonwealth, which is a state cabinet member, and the request is then forwarded to the Office of the Attorney General, reviewed for legal sufficiency. So for all of these reasons that we were talking about earlier about whether, about words mattering and whether or not something is a constitutional law, you are going to be relying on your attorney general for that interpretation. And so when you know that you are the local prosecutor in a state where people may be coming to you, there's not much you can do at that moment in time. But when there is an extradition warrant that has been granted by the governor's warrant has been issued, and that individual then is in your local district court to be picked up or sent to the demanding state, there is some question about whether or not we have any right to voice our opinions about the concern of due process regarding that other state's warrants. It definitely falls on the shoulders of your attorney general. And again, that is why elections matter. But we should be paying attention to this, because I believe, and I'll look to both my fellow panelists here, Virginia is becoming one of the remaining states, of the South that does have, clinics that are and hospitals that do perform this necessary healthcare measure. And so I think for anyone who is in a state that is still, welcoming women to have this, to make medical decisions for themselves, that we should be prepared for the increase of individuals coming to our states and figuring out, knowing that the law is very specific about extradition, but wondering if we do have any type of voice to express at that moment in time when they stand before a judge, if we can offer our opinion regarding constitutionality.
Dean Mutcherson, I want to bring you into that conversation specifically around extradition. How far can states go when they're criminalizing abortion in terms of other state conduct? And can prosecutors in states that allow more access to abortion, can they refuse requests for extradition of abortion providers or patients, or what strategies can they adopt?
Yeah, well, if you're lucky, you're in a state that tells you can't extradite, right? So we have a number of states that have done that now. I'm in New Jersey. People can make fun of New Jersey all they want to, but we are one of those sanctuary states. Oregon, Washington, California, obviously lots of other places that have taken very significant steps to protect abortion providers in their jurisdiction, and also to protect the medical records of people who get abortions out of state. Right. So saying you can refuse to respond to subpoenas. So that's sort of the first line, I would say, kind of defense, right? That your state may have actually taken pains to protect you from having to make those decisions as the prosecutor, because they're saying that you simply can't do it at all. I think the harder question is for folks whose states haven't done that yet. And suddenly they're being faced with these kinds of requests for extradition. And I think part of what makes it so difficult is that in the typical case, we want states cooperating with each other, right? If somebody's done something awful in a particular state and they want that person back there to prosecute them, normally that's a thing that we would, want them to be prosecuted for. But normally it's also illegal in the state that they ran to. And so what's really making this different is that states are trying to punish people for engaging in legal conduct across state lines and then coming home. And there are so many ways in which that is deeply problematic, just thinking about how our system typically works. But it's also deeply problematic. And this is a thing that I think, is so important in all these conversations, is sort of thinking about, okay, what are the other instances, right? Once we open up that Pandora's box, what are the other instances in which we would be comfortable doing that, in which we think it's appropriate to do that, and how far down the line are folks willing to go here? And so I think we have these sort of intrastate and interstate questions that are going on, but we also have some really interesting federalism questions that are going on as well. So it's a morass. It's great for law professors, not so great for people who actually have to do their job every day.
Well, since you are a law professor, I'll stick with you for a moment. And, what are the legal bases that are being offered in support of laws that are prohibiting interstate travel? And what are the counter arguments to those laws? You mentioned the Idaho law previously, but what are the responses?
Yeah, so you have some of this. So the Idaho law, for instance, basically sort of fits into other kinds of laws that we might see, right? Where we say you can't take a minor over, over state lines to do something that is, problematic. But again, what we're talking about here is legal behavior that is taking place in another jurisdiction. So, there are always opportunities to create, relationships between states in order to deal with criminal behavior, but it's pretty unusual to do it in the way that it is being done now. And the justifications that people are putting on the table aren't particularly good justifications, right? Part of what happens, the other stuff that I teach is family law, in addition to teaching, these things. And one of the things that's so difficult about family law is that it's 50 state law, right? It changes as you cross state lines. And normally what we want is for states to respect the laws of other jurisdictions. And that's not what's happening here. So I'm not sure. Once we start seeing more statutes like this, we are going to start seeing more lawsuits. It's just inevitable. And so they are going to end up back at the Supreme Court. And maybe Justice Kavanaugh is right. Maybe there's going to be a 5-4 or a 6-3. Maybe it's going to be 9, who knows, who say that this kind of legislation is unconstitutional. But it's going to be a while before we see how that plays itself out in the court. And we're going to see more of these statutes because of what I said about medication abortion, which is if you really want to stop abortion, you have to go after all of these different pieces, right? You can't just ban in your own jurisdiction. You have to go after medication abortion. You have to go after providers. You have to go after people who cross state lines. And ultimately, you have to go after the pregnant people themselves. And that is a real difference in what we're seeing now from what we have seen in the past. And that, again, will only get worse.
Dr. Brandi, I want to turn to you about specifically on this question of interstate travel and how that affects you in terms of the advice that you give to patients who are pregnant, and what can doctors do differently to minimize criminalization when a patient may be in a state that has heavy restrictions and needs to travel out of state.
I mean, it's really complicated. I will say mostly because I'm not a lawyer. So I don't really know how, each person's individual state laws and how they'll be interpreted if they travel to me in another state. I will say that I have seen patients from other states to take care of them. And it's always a really nebulous conversation that often, unfortunately, pits the doctor or the healthcare team against that patient, where for example, medication abortion. If someone is coming to me for medication abortion, usually the general instruction is that, you take the one medication with us and then you take the rest at home. And that feels kind of murky now because we don't know whether or not patients can actually complete their medication abortion in their home state, or if they should do it here to protect the provider. And again, like, it's not changing the medicine. It doesn't make the medication abortion more or less safe for that person, but it protects me potentially from all of these other concerns if I would be prosecuted from another state. So it creates this like unnecessary divide between patients and providers where we have to be distrustful of each other, which creates moral injury to the providers because we came into medicine because we want to help people and not, we're not cops. We don't want to be turning people over to the state. And yet it feels like the state is requiring us to do these kind of things. And looking at numbers about criminalization, that it's mostly the providers, it's mostly healthcare people that are turning people over to these institutions and for criminalization. So we're doing work within medical fields to make sure that people know that that's not a thing that we have to do. But there's already this dynamic about people traveling across state lines. I also just want to recognize that it depends on the situation of that person, because there's many people that are traveling state lines when it is dangerous to do so for their own health. The people that are seeking care in these emergency situations where their water is broken and they're like counting down the clock until they become septic and die, or they're bleeding and are waiting to hemorrhage just enough to get their care in their state versus getting it in somewhere else. And will they hemorrhage en route to that place? And so we're making these unnecessary and really harmful decisions about where patients can get care, which is against our oath. It's against what we signed up to do, to take care of people. But if that's the only way that they get their care, then that's what we're doing. So it's just really murky and terrible conversations.
Yeah, it seems to one of the points you made, we now have prosecutors having to learn medicine and we have doctors now needing to be lawyers. I wanted to bring you in, Dean Mutcherson, for your response on that point.
Yeah, another piece that I think is so important here, and I say this in part because I was asked in the last couple of weeks to review 2 different papers about physicians' obligations to share information. So even if you can't provide an abortion, if you say, well, you can go across state lines, or I know this doctor who will do this, or et cetera, doctors are even scared to do that, right? To refer somebody to someplace else where they can get that kind of care. And that is just shocking, right? The idea that as a physician, you would say, here's a thing that a year ago I could do for you, but I can't do it for you now, nor can I tell you where you can go. Even if I know it, I will not tell you where you can go in order to get that care. So that's raising obviously professional ethics issues. It's raising issues about malpractice. And frankly, it's raising First Amendment issues, right? It is a muzzle on healthcare providers. So we'll see that litigated as well. But we have to wait for all of these things to make their way through the court, unless someone in a particular jurisdiction is willing to say, we're not going to prosecute for telling somebody where they can get healthcare, or we're not going to prosecute for X, Y, or Z thing. And there are lots of reasons why prosecutors would not necessarily be comfortable doing that, which I totally get. But I also think that there are lots of healthcare providers who, even if a local prosecutor said, I'm not going to prosecute you for that, why would you risk it? Right? If what's on the line is your license to practice medicine and your freedom.
Mm-hmm. And I just want to add to that point that is really what's on the line for a lot of providers, or at least that's what our perception is about that line, that we are worried not only because we want to provide care, but we may be breaking the law. We are definitely rule followers, so that makes things complicated. But it's also this fear of like, if I lose my license for this one case, then all the other patients that I could be taking care of, not just abortion, all my labor patients, all of my patients that are getting pap smears, If my license goes away, that whole community loses a doctor, loses a provider. So that feels like big stakes. And that creates this chilling effect because doctors don't want to engage in that. We also know that, like, it's not just me, it's also going to implicate my nurses, my staff. Like, the broader impact of that is just so scary to us on the ground that it's just not worth it for a lot of people. And that ultimately creates a chilling effect that's going to prevent people from getting care.
That's a really important point. I want to kind of call out what may be an elephant in the room, the virtual room that we're in, which is that some prosecutors have criminalized pregnant people even before the post-Dobbs laws came into effect. And I shouldn't just say prosecutors, I should say laws have criminalized pregnant people. Dean Mutcherson, I see you nodding. What are some examples of ways in which prosecutors have used pregnancy as a way to criminalize conduct?
Yeah, so there are a couple of really prominent ways in which this has happened. One obviously is pregnant women or women who've just delivered, who end up being prosecuted for using illicit drugs during their pregnancy. One of the most prominent instances of this was the Ferguson case that ultimately went up to the U.S. Supreme Court, which involved the Medical University of South Carolina, where they created a program that was created with healthcare providers at a public hospital, the local prosecutor's office, and the local police department, where basically if women showed up and they were tested, not told that they were being tested for illicit drugs, but they were tested. And if they had dirty urine in the beginning, they would immediately call the police, and then they decided that was too harsh. And so the next iteration of the plan was, well, we'll give you a chance, to go to rehab, and if you have another dirty urine, then we're going to call the police. So, we have some women who, just horror stories, right? Women handcuffed to their beds right after they delivered and they're still bleeding because they had tested positive. So that is, one category that we have seen for a very long time in this country. And in the Ferguson case, the racial implications of how the criminal justice system has been wielded against pregnant people were just so stark, right? So of the women who were tested and of the women who were the plaintiffs in the case, all were African American, except for one woman who the nurse wrote on her chart that her boyfriend was Negro. This was not that long ago. So, the race and class implications are very, very clear here. And, I, for one, am certainly in the camp of believing that substance use disorder is a public health problem, not a prosecutor problem. But in any case, it's not quite clear who you are benefiting when you arrest a woman right after she's delivered a baby. And then the second category is women who are being targeted for other kinds of behavior, particularly if they are suspected of trying to terminate a pregnancy or are suspected of having done something during their pregnancy, right, beyond illicit drug use that caused either a stillbirth or that caused them to miscarry. And those cases are, going back to the question of proof, those cases can be incredibly difficult, right? In trying to prove that what happened here was somebody who actually was trying to self-manage an abortion versus somebody who, did actually fall down a set of stairs or did actually, have something really tragic happen to them. And again, I think the question that we have to ask ourselves is whether these are issues that are best played out in our criminal justice system or are best played out in our mental health system or best played out by public health concerns. And I think in the vast, vast majority of cases, moving people into the criminal justice system is really not going to be the best direction to go in, if for no other reason than recognizing that a lot of these women, right, we know that the vast majority, that the majority of women who have abortions already have children at home. And they are mostly poor, that women of color are overrepresented, particularly Black and brown women, and the women who terminate pregnancies. And so the more you start to criminalize activity during pregnancy, the more we're going to see the kinds of collateral consequences that don't just impact the pregnant person, but impact their families and impact their communities. So, when I arrest you because of your illicit drug use, then those kids that you left at home, because you already had kids at home, who's taking care of them? Are they going into foster care? Are you going to get kicked out of your housing? Are you going to lose your job? Are you not going to be able to participate in that educational program that you were going to participate in? So everything that flows from that can be really, really substantial. And then the last thing that I want to say here, because I think that this is a space where people get really uncomfortable, right? Because there are all of these expectations and myths that go along with pregnancy. Everybody doesn't enjoy being pregnant. I've been pregnant twice, not the most enjoyable time periods of my life, quite frankly, for a whole host of reasons. Everybody isn't pregnant because they want to be. Everybody's not having a baby with a person who they feel safe having a child with, right? I mean, people's lives are very complicated and nuanced, and there is never a one size fits all solution. But a solution that almost never fits is putting somebody in prison.
Thank you, Dean Mutcherson. I want to bring you in, Commonwealth's Attorney Taylor, and to respond to what we just heard. And as a chief prosecutor, what lessons do you think should be drawn from the examples we just heard as prosecutors are navigating this post-Dobbs world?
I mean, I think Dean Mutcherson, she touched on it, perfectly. I mean, the reality is that we have known, we know better today than we did 25 years ago about substance use disorder. And we have slowly but surely come around to the idea that, with the acceptance, some of us have been saying this for a long time, but I feel like there's a majority of people now who believe that really is a public health crisis. And, to use the public safety statement of you can't lock yourself out of that problem. The war on drugs was really kind of a misnomer, but I should not be disrespecting the fact that we now do have a crisis on our hands with the type of, whether it be the fentanyl or the new horse medication. I can't remember how to say it, but like there are serious things that are happening out there. And and for us, we should really be focusing on the track to treatment, the track to a healthy lifestyle. And I think the same thing that we're dealing with here is that this is a health decision that a woman is having to make. And the idea that that I will say that there was a letter by the Fair and Justice Prosecution where I believe it was 60 prosecutors, some have probably on this call, I was one of them, who said, we are not going to prosecute a woman for making a health decision. I think my colleagues should all find comfort in everything we were talking about earlier about this very real issue of constitutionality. We should feel comfortable in saying that we are not going to do this, because I can tell you right now, I can't think of any legislation that would come down prohibiting this decision that is going to have the terminology or anything of that nature that is going to stand constitutional challenge. So I feel like we should stand up, feel comfortable with it. This is not a selection of law. This is literally, there is a constitutional argument here. And then lastly, to say that we are the ones that make that decision. If they put the laws on the book, we are the one person to say, we're going to go forward on this or we're not going to go forward on this. And getting back to some of that interstate commerce, the idea of someone in Texas who comes to Virginia and Texas wants to prosecute you, how are they going to get that evidence from Virginia? Like, how is this going to work? Are we going to say that they have the ability to work with our local law enforcement when we know that what they're doing is trying to find evidence for a law that is not constitutional? So it is very possible that here in the next 12 months, you'll be seeing some prosecutors who are going to have those real challenges. And I certainly implore those to speak up loudly, given the opportunity, like those of us who signed that letter, to say what the problems are and be bold.
Yes, and in the subject of speaking to prosecutors, the IIP is here to share resources and support. So please turn to us for guidance, regardless of whether you're in a state where abortion restrictions have been added post-Dobbs or not. I want to turn to some questions from the audience, but before we do that, I want to give everyone a chance to sort of do a lightning round, quick question. I'll start with you, Dr. Brandi. What is the one message you want to deliver to the prosecutors who are watching with us today?
I feel like I really can't narrow it down to just one, but I think we talked about some of the things that I really want to talk about. I did want to add in that exceptions are really meaningless in these laws. And that's a really important thing to highlight, is that they are meaningless medically. And it's important for people to recognize that not only are they meaningless, but they're not actually protecting patients in any way. They're only creating more barriers, delaying care for people. And it's really creating this barrier where we're having to pick our oath to our patients versus protecting ourselves and following the law. So even if you think that it's helping people, just know that it's really not.
Dean Mutcherson.
I would say that I think that knowing, taking opportunities to make sure that you know exactly what's going on and what's being talked about, like participating in this webinar, is just so crucial, because there's so much noise out there, so much rhetoric, so much politics, right? And ultimately what we're talking about are individual people who are just trying to figure out how to get through the day and just trying to figure out what decisions that they are going to make, that it makes sense for themselves and makes sense for their family. So, getting down onto that level of really sort of understanding these issues and where they're coming from and the impact on individual people's lives is I think just such a crucial part of this discussion, because it's really easy to have opinions when you don't know how people are hurting.
Thank you. Commonwealth Attorney Taylor, I know you spoke to this a little bit, but what is, in the lightning round, one quick thing that you want prosecutors to take away?
Yeah, words matter. I mean, this is a lightning rod subject. It is a partisan issue. There's very strong political feelings about this. But at the end of the day, as lawyers, we have an obligation to the law, to the Constitution, and that should really be the controlling factor.
Thank you. I'm going to turn to some questions in our last few minutes before we wrap up. We have a question that asks, how in practice are banned abortions coming to the attention of police and prosecutors? Are healthcare providers reporting them? Acquaintances or exes snitching? I've heard on social media that in Texas, public health staffers have been attending at women's homes to ask about the outcome of their pregnancy. Dean Mutcherson, do you want to take that one?
Yeah, I can certainly start, and then I'm guessing that Dr. Brandi has some thoughts on that too. The things that I am hearing and reading, and from talking to to folks who are providers, is that sometimes it is the healthcare workers, right? It's not the doctor who's providing the abortion; it's the nurse who was in the facility that day and said, "Oh, that wasn't supposed to happen." So we obviously see those kinds of things happening, and then we have things like SB 8 in Texas, which actually, literally creates a financial incentive for people to turn in their, whoever, their neighbors or friends, whomever. And again, we have not seen a lot of litigation there, because all you have to do is create the risk, right? And then people get scared. And so they're not telling anybody, they're, sneaking across the state line. And all of that creates, various types of danger. One thing, just in case this sort of comes up as people are thinking about this particular question, is that obviously there are HIPAA issues here in terms of sharing people's health information, and HIPAA, like EMTALA and all the other good, acronym laws, has all sorts of exceptions for law enforcement. But the idea of somebody simply calling up because they think that they're required to do that is a reflection of people whose hospitals or whoever have not given them the proper information, right? Because there's no reason why, and there's no obligation that people have in any of these laws who are healthcare providers to pick up the phone and start turning people in. So that's a very tricky piece there, because it's also one of those things that makes people afraid, right? So if you are having a bad outcome and you think, oh my gosh, what if I go to the emergency room, are they going to call the police? I don't want you hesitating to go to the emergency room. I want you to go, and I want you to get the care that you need. So that's a big issue with how hospitals and other healthcare facilities are training their workers about what they're allowed to do and what they're required to do.
Dr. Brandi, did you want to add to that?
Yeah, and I would second that opinion that I give my patients all the time when they have a medication abortion, is that if you go to the ER there's no way for me medically to tell whether or not it is a miscarriage or medication abortion. They're literally the same process, it's just one is being started by medicine and one's not. But now I feel like I can't give that advice because I feel like, and now it's more like, is everyone going to be considered to be a medication abortion until proven otherwise? And there's really no way to prove it. So I will say that I think the data I saw recently was like over 50% of people that are criminalized for self-managing their abortions, the process started from a healthcare provider reporting them. And so it is mostly on us as healthcare providers. And I've been part of a lot of work within healthcare spaces to educate our healthcare providers, reminding them that HIPAA is our, duty to our patients to protect their information, to not act as police enforcement, because that's not our job. And also particularly, how do we focus on documentation? How are we documenting only the pieces of medical care that are relevant to other providers and not necessarily documenting things that are going to put our patients in danger, making sure we're using proper language. I've been talking to radiologists about the ultrasound reports that they generate and how they don't have to include information that could be incriminating. So we are doing work on the healthcare side to make sure that we're protecting our patients, but I'm hopeful that people on the legal side are also doing their part too.
Another question, I think, directed for you, Dr. Brandi. Given the risk of criminal charges, doctors in states with abortion restrictions are hesitant to perform abortions under any circumstances, even when the state's law claims to allow exceptions for when the life of the pregnant person is in danger. Some doctors are now seeking legal advice prior to performing abortions. What are the dangers, if any, of reaching out to counsel? For example, do doctors make themselves even more vulnerable to prosecution by doing so? So there's a medical question and a legal one there. I don't know if you want to start, Dr. Brandi.
Okay, sure. Yeah, so I alluded to this, but I didn't get a chance to explain like how the exceptions are not actually helpful in medical practice. So for example, when you say something like the health and the life of the mother, that is super nebulous. Arguably, if you want to be super snarky about it, I said pregnancy is always more dangerous than not being pregnant. So ending a pregnancy will always make a person more safe. But that being said, when someone is at health risk, like when I should be intervening to provide them health care, is really a medical determination. And often it's like right then and there. Like if someone presents with an ectopic pregnancy, I'm going to manage them right then and there. I don't want to wait to do surgery that they need emergently. But these laws are suggesting that someone really has to be critically ill. Which again goes against our oath of like taking care of patients. I don't want to wait till someone is critically ill. I could fix this problem now and not wait 3 days when they get much sicker and have a higher risk of death. But that's the confusion, is that we don't know what is sick enough because we've never been asked this question before. And so figuring out what is sick enough is not really a medical interpretation. It seems at this point now it is a legal interpretation of like what would be okay enough that we probably would be able to argue it in court. And so that is causing us to reach out to lawyers in our spaces and causing us to delay care until we can both reach out to those lawyers and also meet whatever criteria that is, again, not medically based, but just trying to do something to protect ourselves, which feels awful.
Can I just add something for Dr. Brandi? I mean, I think someone had said one time that it is economically more feasible or, more reasonable to be sued for malpractice than it would be to have the aspect of the criminal prosecution. And the idea that there's literally hospital counsel out there who says, don't do that because we know it's against the law, but, we'll be able to handle the lawsuit, the medical malpractice because we've got caps in our state. I mean, that's a really kind of an extreme example, but it is kind of this offensive dialogue and choice that is being made in some circles. And Dr. Brandi, I don't know if you had anything else that you wanted to say about that comment, but it was to hear about that.
I've heard that like really like we're, doomed either way. We're going to get sued for malpractice if we wait too long and are doing actual negligence to our patients, or we're going to be sued criminally. And I've heard that people are kind of leaning toward like taking the hit on the malpractice side to avoid the criminality. Also, because most of the people that we engage with are more malpractice lawyers. They know how to manage that in a healthcare system. Most malpractice lawyers don't know how to deal with these criminal suits that we would be put up against. So it just They would rather have the malpractice. And also, by the way, there's a patient in the middle of this. Like, it's this hypothetical legal argument, but there's a patient that is waiting and dying and being played around with in this decision, which is really heartbreaking.
And just to make it even more complicated, just to add another piece to the puzzle, is EMTALA versus these medical exceptions, right? So, Texas, of course, is also suing because the federal government came out and said, EMTALA, the emergency medical treatment, I never remember what the whole acronym is for, but basically, the patient dumping law, right, that Congress had to pass, because at one point hospitals were, somebody would come in, they didn't have insurance, and the hospital would be like, we're going to just put you at the bus stop and hope somebody else takes care of you, which is not good medical care. So, EMTALA requires that if a patient shows up and they are in an emergency state, that you have to stabilize them. And the federal government has said that stabilization in some cases could include an abortion, right? If that's what you decide as a healthcare provider, that's what it means to stabilize this patient, EMTALA and HHS say, go ahead and do the abortion. But then you have individual states that might say never, right? I mean, Texas is saying that their law should supersede federal law, which everyone who's been to law school will say, no, federal law trumps. But somehow, right, this is where we are. So it's not even that you're trying to question what the exception means. It's like, does the exception trump what the federal government has told me that I have to do? So, healthcare providers are being pulled in so many different directions when the only direction they should be pulled in is what's good for this patient and what should I be doing for this person?
Yeah. And by the way, this is all happening at 2 a.m. So yeah, it's been really challenging to figure all these things out with no legal background. And it's just really confusing for everybody.
On that subject, Dr. Brandi, comes our last question, I think, that we have time for. Excuse me. How, if at all, have abortion restrictions impacted educational institutions, particularly medical schools, and the training required of prospective OBGYNs? Excuse me. Dr. Brandi.
Yeah, I mean, thank you for that question. We haven't seen the full impact just yet, but we're going to be seeing that, probably in the next couple of years. We've already seen that medical students applying for fields like OBGYN and family medicine that provide the majority of abortion care, the numbers of applications are going down, and particularly going down in places where there are abortion restrictions, because they know they're not going to be getting adequate training to be able to take care of everybody that they need to take care of. And I think that's concerning just baseline, because that means that people are going to be less and less trained to provide this care and provide obstetrical care in general. But what does that look like 5, 10, 15 years? What that looks like is people that care about this issue aren't going to be going to the places that need them. And those places are not going to have any type of healthcare provider or reproductive healthcare provider. Because if you don't have an abortion provider in that space, you probably also don't have a laborist in that space, because that person didn't decide to do their training there. And so I'm worried that it's already going to exacerbate the deserts that we have around abortion care, but also maternal health care, labor care. Often that map is intersecting, like the places that have no abortion also have really difficulty accessing labor care. And that's only going to get worse and worse as less and less trainees go into those places.
Which, of course, brings us to where we started, which is that poses a significant threat to public safety if people cannot access the healthcare that they need. We could certainly go on for a long time, and the IIP will continue to share information, resources, and advocacy on this topic and on reproductive justice more broadly, which continues to be, as we've just been talking about, a key aspect of promoting safety for all communities. I did want to point out one quick resource for some of the prosecutors who are watching. I wanted to point out the Public Rights Project, which supports prosecutors named as defendants in abortion litigation. PRP supports pro-choice prosecutors in abortion litigation and has supported prosecutors named as defendants in state litigation who are trying to advocate for abortion rights, those who are interested in using their authority in investigations and litigation to advance access, and those who've been personally threatened for their views, our First Amendment speech, as we've been talking about, or official decisions regarding prosecuting abortion. We'll drop a link to them in the chat. That is a resource we wanted to make available. And of course, you can turn to the IIP for additional resources as well. We'll put our link in the chat as well. You can also learn more information on today's speaker and watch today's recording, which we will post as quickly as we can after this event. And please sign up for our mailing